The court next calls the case, the matter of the marriage of Lydia Van Vele and Troy Van Vele, case 194401679. If I could have the parties please state your appearances.
Ron Wilkinson, Your Honor, appearing on behalf of the mother in this matter.
Your Honor, Matt Olson, representing the father who's present with me.
All right. Thank you, counsel. I understand we have an objection to Commissioner's recommendation pending. And I think the reason I scheduled this, if I remember, counsel, is lately I've just been trying to schedule a brief status hearing so that I know exactly what the parties want to do, how much time you want to take on these commissioner recommendations, if you want an evidentiary hearing, etc. So let me go ahead and ask if I could, Mr. Olson first, what is your approach or proposal here for presenting on this objection, please?
Your Honor, I think we'd probably ask for an evidentiary hearing. It's kind of a limited issue, but I think it may need the testimony of the parties to outline what they understood.
I see. How many witnesses or length of testimony? Do you have any estimate, Mr. Olson?
Your Honor, I would think total probably just a couple hours of what we're looking at.
I see. Mr. Wilkinson, what is your view?
Thank you, Your Honor. We would object to an evidentiary hearing, Your Honor. This is just simply a issue of contract construction. The language of the decree itself is, we believe, unambiguous, and there would not be a need for extrinsic evidence. Having the evidentiary hearing just as an attempt, we believe, to redo the decree where the language is clear, and I think the commissioner appropriately interpreted it. So it's an issue of law.
Mr. Olson, would you like to reply to that?
Yeah, Your Honor, again, it can't be an issue of law, and it can't be merely interpretation because these parties have been doing something for over 2.5 years.
All right. So obviously, I'm going to need to make a decision on that exact question. I've read through the memos here. I just want to make sure. So I have that paragraph in the decree. This equals 12 days in a 30 to 31 day period. So Mr. Olson, so I didn't intend to get into argument today, and I won't be making a decision today, I believe, but I just want to understand your interpretation, not necessarily of the substantive language, but why you believe that the language needs to be interpreted with a view to practice. Is that based on some principle of contract law or what?
Your Honor, basically, during the parties' mediation and subsequent decree of divorce in this matter, the parties worked off a schedule, which would be his work schedule. And it does start on a Friday, but if you start the first Friday of the month, it negates his ability to exercise 12 out of 31 days.
It's a 7 days off.
Yeah. He's on a 7 days off in a row type situation. So it does start on a Friday, but it can't necessarily always start on the first Friday of the month because the schedule is rotating on an annual basis.
I've seen my children.
Yeah. Okay. Yeah, I understand. This is essentially just the argument. All right, Mr. Wilkinson, just to possibly try to obviate the need for argument on this procedural point, I would at least like to have oral argument, which we're not going to do today. And if I conduct it by way of proffer, as we often call it, which sometimes just ends up being oral argument by the attorneys, I think I could determine, as long as I have the parties there, as we have the initial oral argument, I can determine if I believe there is grounds for taking evidence or not. And as long as both of you agree, as I think Mr. Olson said, that this is going to be fairly limited, fairly brief, then I don't know that it necessarily matters if we decide right now if I'm going to hear some brief live testimony from the parties who will be present anyway, or if I'm only going to hear from the attorneys with some proffer or maybe just oral argument. So I think I can postpone that decision if I even have to make a decision on that to the time when we hold the hearing. Mr. Wilkinson, what do you think about that approach?
Yeah, and I think that's a good practical approach. My only concern would be that it would certainly be additional time and expense for both parties if we have to prepare them to testify. So I would just want to know ahead of time if there was a need for that, which I think we could determine after doing oral argument.
I see. Okay, so there's another proposal there, Mr. Olson, which is that we have an oral argument. Basically, I hear from the attorneys, and if I believe that testimony is necessary, that we would schedule that. I mean, I don't think there's any way I'm going to be able to stop each of you in oral argument from making a proffer about what your parties, what your client understood or agreed, and you may very well make objections. That's always a little bit confusing when I'm essentially not hearing evidence, but there's objections being made. So that's one way we could do this, just to try to get to it as quickly as possible and then take it one step at a time. Mr. Olson, what do you think about that? Again, the proposal is schedule only oral argument with the court making a determination at that oral argument of whether I need to hear a testimony or not. Mr. Olson?
Your Honor, again, it would seem like to me that would be more cost because the issue is so limited. Again, I can't imagine we couldn't prepare our clients just as to that one issue and have them available again when we're making our oral argument. And if the court does want to hear it, like I said, I would think it'd be more cost if we have to come back a second day if the court does determine it's necessary. Because it is pretty limited, Your Honor, and the testimony would be pretty limited. I don't know, a lot of preparation would have to occur in regard to that limited issue. I mean, I think it's cheaper to all of us come there, we're there. If the court doesn't want to hear from either one of the parties, it's pretty limited in regard to what the court would hear from them.
And Mr. Wilkinson, again, your objection to handling it that way is you believe that if the court is going to call the parties as a witness or ask you to call the parties as witnesses or hear any live testimony, that you would approach that hearing differently or prepare them for testimony, Mr. Wilkinson? Is that the concern?
Yes, John, I would prepare my client to testify. And I mean, I guess the thing that's curious to me is what is it they would testify to? Their understanding? I mean, we need to first make a determination if there's an ambiguity, and then if that ambiguity can be resolved within the four corners of the document, and only then would the court look at extrinsic evidence. So I wouldn't want to go into the hearing not knowing whether or not whether or not there was an ambiguity, and two, what the claim was in terms of what facts would be alleged or testified to as it relates to that ambiguity.
Okay, well, often I do this in criminal cases, which is having a motion filed and determining if I need an evidentiary hearing. The rules of criminal procedure actually provide for that exact specific process, as do the rules of evidence, as you know. So that's the way I will handle this. We will get together for an argument on the motion, and then as the argument proceeds, based on my determinations, either procedural determinations or substantive determinations about the contract itself, I will then let the parties know if we need to have an evidentiary hearing. I don't know which way my determination on that will come out right now, so I can't tell you whether or not we're going to have an evidentiary hearing. Because there is a possibility that we will not have an evidentiary hearing, I believe it is efficient to go ahead and schedule this portion right now. Mr. Olson, you are correct that if we need to then reschedule another evidentiary hearing, then that would be additional time and effort and cost. But the likelihood that we will not do that for me militates in favor of just going ahead and at least getting started with what may be a more brief hearing to start out. So I understand that you both have disagreements about how to handle that procedurally. I am erring right now on the side of trying to keep the hearing as short as possible, just in case I do not see the need for an evidentiary hearing. And I will promise the parties right now, just so that we keep it short, I will promise the parties right now that I will not hear testimony at the first hearing that we call. Now, all of that is contingent on whether we can find a time in your schedule in the next 1 month, 2 months, 3 months, 4 months, dealing with attorneys recently with trial schedules. I know that we're all booked up for many months, and so if I do it this way with no testimony, and I'm simply hearing argument from the parties, which I probably could have done today, but you just never know on this. I mean, we could be doing it right now and maybe I could make a decision, but I didn't prepare you for that. Unfortunately, I've had too many train wrecks on objection to commissioner recommendations. So I like to have this brief pretrial conference just so I know what to prepare. So let's look for. I think we could do that in an hour. It sounds like then, if I'm just hearing argument from the parties, Mr. Olson, for at least this first phase of argument on this motion. Do you think that would be sufficient, Mr. Olson?
That'd be sufficient, Your Honor.
Mr. Wilkinson, do you agree?
Yes, Your Honor, I think even 30 minutes may be enough.
Okay. All right. Let's ask the court clerk for an hour block. Hopefully, we'll use even less. And let's try to do this anytime in the next several weeks here. For Callie Stevenson, the court clerk, please.
Judge, do you want to do it over a lunch? A lunch
You know,
hour?
I will ask the attorneys if you have some of those available times. Let's try that. I will ask the attorneys if it's a day that works okay for them to do it over a lunch. I think that's probably a good suggestion here, as long as it's not a critical day for council. Let's make some of those suggestions. That's a good idea, Callie. Thanks.
Okay, November 17th.
November 17 is a Thursday, council. If you look at your schedule there at approximately noon.
You know, I'm out of the country until the 21st.
Okay, we'll go to another date, please.
November 23rd.
The day before Thanksgiving.
That's going to be problematic for me. I may be out of
Okay,
town.
let's go to another date. Now Callie's going to start scheduling these on a noon when I'm in the middle of a jury trial, right? So we'll all be juggling here.
About December 6th at 11.
December 6th is a Tuesday.
I'm good with that, Your Honor.
And I'm in trial with Judge Brady, the 4-day trial, the 6th through the 9th.
Okay, try another day, please.
December 14th at noon.
December 14 is a Wednesday.
That'll work for me, Your Honor.
I'm in mediation. If I can do it via Webex, I'll be in Salt Lake, but I think I could make arrangements and do that remotely.
I appreciate that, Mr. Wilkinson. This might allow some flexibility here. And I understand if you're if you're taking the lunch from mediation, then you could be a few minutes late and eat while we talk. I don't know. We're just trying to fit this in, and I appreciate your consideration on that if we could. So we said
I apologize. Excuse
sorry.
me. I'm not,
Yes.
would I need to be present? This is Miss Vanveli. Would I need to be present because I'm so sorry. I'm not available the week of the December 14th due to work restraints.
I see. Mr. Wilkinson, what do you think?
I think it's most helpful if a client's present in case there's questions, Your Honor. If it doesn't put us out too far, I'd prefer to get a different date. If it does, I would feel comfortable going forward since it's primarily legal argument.
Anything else, Callie? Another date?
December 21st.
Let me ask you this, Callie. I don't know if you've already checked. Do we have anything? Oh, next week. Oh no, next week we still do have the trial, right? Like
Yeah.
November 1, 2, 3, 4. Oh yeah, we do. Okay.
We could do it at lunch one of those days. Or the 4th.
Is there December 20th? Is it a possibility, the lunch hour? I'm in trial the 21st and 22nd in front of Judge Holmberg in the 3rd District. But
No, we have veterans.
I have Veterans Court staffing during the lunch hour on December 20th. I'm sorry.
no worries. Thank you.
I can do the 21st, Your Honor, if that Mr. Wilkins is available.
No, I have trial with Judge Holmberg the 21st and 22nd.
No, that won't work.
Did I say November? Judge, November 9th.
Yeah, November
I
9.
don't know how long that morning hearing's gonna go.
Let's have counsel. Can you look at your November 9th, please?
And I apologize, Your Honor. I'm out of the country.
Oh, right. That's the week you're out of town. Okay.
I'm gone a couple weeks. I apologize.
Can we do the 14th of December then, Ron?
Just keep it the 14th of December for legal argument.
If there's nothing in December, I can do that. I'm working all between Christmas and New Year's. I know that's a good time often for the court to take off, though.
And then I'll be gone.
Mr. Olson's not available. Well, December 14th, Mr. Wilkinson, I think you're the one who said this is legal argument. It's a contract speaking, so this would be one time, I guess. Obviously, if there's something that you needed your client for and we were not able to answer, then I would give you an additional opportunity to consult. But let's try to have the legal argument, which would be at least the first phase, or possibly the only phase of this objection.
That would be great, Your Honor. Thank you.
My ruling. Okay, so Wednesday, December 14th is what we're saying. Wednesday, December 14th at noon on Webex. And I'll just make sure I'm ready with those citations that you've made, and we'll try to make it as efficient as possible with legal arguments on the objection. And Ms. Van Bailey, certainly you can communicate with your attorney before then about any questions or anything that you want emphasized. Okay. All right. Thank you for your accommodations. The hearing will be Wednesday, December 14th at noon on Webex for no more than 1 hour. Okay.
Thank you.
Thank you, Your Honor.
All right. We'll see you all then. Thank you very much.
Thank you.
Goodbye.